Hello everyone, this is Assistant Professor Nilima Nimaje from Department of Management Studies, and we are going to look for the subject Business Law today. In Business Law, a very important chapter which we are going to look today is Indian Contract Act 1872. So let's take a brief intro about Indian Contract Act. So this act is based on the principle of English law, which has came into force on 1st September 1872. This act is applicable to entire India except Jammu and Kashmir. Law of contract exclude obligations which are not contractual in nature. This means what? There are certain contract, only that contract can form and contractual in nature. Like for example, when I talk like, will you purchase my flat? So this contract, this agreement can be turned into a contract because law obliged it. But when we take an example, like for example, you ask your mother to make an biryani for you, and like if she denies or if she do not make an biryani for you, so that agreement cannot be turned into a contract. So there are certain contract only which can be obliged by the law. In the same way, all contracts are agreement, but all agreements are not contract. It means like each and every contract is an agreement, but all agreements are not the contract. Just like in the case when you ask your mother to make an biryani for you, that if she denies it, you cannot take her to the court and ask or claim any law against her. So every agreement is not a contract, but all contracts are the agreement. Now, law of contract create jus in personam as distinct from jus in rem. Jus in rem means right against or in respect of a thing, and it is available against the whole world. This means what? Like, let's take an example for this. If you are if there is a builder and you have purchased a flat from him, it means you have entered into a contract. Once you have paid the amount, he will hand you hand the keys to you. It means what? Once the contract is done, after that you have each and every right against that flat. Now you can do an wooden interior, you can do an glass interior, you can keep as many as person you want at that place. It means nobody in the entire world will ask you to do like you can do this, you can do that. Nobody has a right to say, because it's your property and you have a complete right against that particular property. So this is called a jus in rem. Next is jus in personam. It means right against or a respect of a specific person. Let's continue with the builder example. Now, builder and you have entered into a contract for a flat. Now, the question is from whom the builder is going to ask you the money from? And the answer is you, because you have entered into a contract, and that's the reason he is the person who is going to, like, you are the only specific person from whom he can demand the money. So that is called a jus in persona. Now, let us look after certain basic terminologies of Indian Contract Act. So here you can see in mobile phone. So we are going to make a continuation for this, but we are going to take this mobile phone as an example to understand all these terminologies. So very first terminology is proposal. Every agreement or every contract start with the proposal itself. Proposal is synonymously called as an offer also. Now let's take an example. Will you purchase my phone for 50,000 rupees? This is an proposal. This is an offer which I am giving to you. Now, once the proposal, the offer which has been given, if it has been accepted by you, then it would be called as promise. So we can say that offer plus acceptance will convert it into the promise. Now, this promise would have consideration. Now, many of them often get confused with this, but what do you mean by consideration? Means what? Like both the parties are considering, or we can say are lawfully considering certain things. Just like for example, in this example, I like when I asked you, will you purchase my phone for 50,000 rupees, and you agreed for this. So what I am going to get is the money, and what you have considered is mobile phone. So here both the parties have considered some or other thing. Like I have considered money and you have considered mobile phone. So that is what called as consideration. After a lawful consideration, if once the proposal has been done, it has been accepted, promise has been there, consideration has been there, that thing is called as agreement. Now, agreement, when it has been enforced by the law, when a particular agreement where the law can come into an action, that agreement can turn into a contract. Now let's take an example. like when we talked about the mobile phone, will you take my mobile phone? You agreed. We have entered into an agreement. Now, in case, can you take this agreement to the court? And the answer is yes. In case if I have denied, you have paid me the amount, and if I have denied you to give the phone, you can specifically take me to the court, and the court will take an action. So law can come into an action in this particular situation. Now let's understand it by for more clarity, let us understand it by another example. Like for example, you made an agreement with a taxi driver to drop you till Vashi. You have considered a ride. The taxi driver had considered the money. Now once you get off to Vashi, you deny giving the money to the taxi driver. Now the question is, can this particular thing can be go to the can be taken to the court? And the answer is no. It's like you cannot. There are certain agreements, like, or if I could say another example is like, if I said that if you pass with a good grades, I will gift you the phone, and certainly you pass with a good grades, and I deny with the fact that I'm not going, I just said it like that only. So this kind of agreement cannot be enforced by law, and henceforth they cannot become an contract. But for enforceability, there are five important things which needs to be considered. Very first is there should be a lawful. Very first is offer and acceptance. So in this situation, there was a proper offer. When that offer got accepted, it became the promise. So offer and acceptance is mandatory for an contract. Second is there should be a lawful object and lawful consideration. So in this situation, mobile was a lawful object, and the consideration was also lawful. In, like, for let's take an example, if we are getting into an agreement for leaking the paper, so the object is also unlawful and the consideration is also unlawful, so that agreement cannot be converted into the contract. Third thing is like the both the parties should be competent. Now when we talk about the competent parties, it means that both the parties should be 18 years and above. Second is both the parties should be of sound mind, and third, the both the parties shouldn't be disqualified by the law. So it is very important to fulfill this particular criteria in order to make an agreement into a contract. And the last is free consent. Now there is a difference between consent and free consent. Now consent means what? Like, let's take this example. If for example I make an offer to you and you denied it, immediately I pull out the gun, I point it on you and say, if you do not purchase it, I will shoot you. So in this particular situation, what you would be doing is you would be agreeing. So that is you have given the consent, but that consent is not in free consent. But an agreement, in order to make a contract, the free consent is mandatory. So whenever any proposal is been given, the consent should be free. Moving towards the next terminology is void, voidable contract, and void ab initio. Now void is something which is not enforced, like in certain agreement which is not enforced by law, that agreement would be called as void. Like for example, we both came into an agreement and afterward it turns out like your age is only 15 years, like you are not fulfilling the criteria of competent party. So in this situation, the contract or the agreement would be considered as void. Second is voidable contract. Voidable contract means either one of the party is accepted and the other party is disagreed. That is what called as voidable contract. So in this situation, the example when I said that when I made an offer to you and you denied the offer, I pull out the gun and you agreed for purchasing the phone. It means what? I was agree, but you was disagree. You agreed, you gave your consent, but it was not your free consent, and that's the reason this particular entire situation was an like we could say it is an coercion. So it is an voidable contract. And last is void ab initio. Void ab initio is the certain thing where the agreement or contract is illegal right from the start in the eye of law. Like law do not enter in, like when we talk about the contract or agreement related to the smuggling or kidnapping, these is illegal right from the start in the eye of law, and such kind of agreement or contract is called as void ab initio. Moving towards next is so definition. Now we have understood all the basic concept or terminologies of Indian Contract Act. Now let us look after the definition. As per section 2 a, proposal means when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that or other to such act or absentees, he is said to make an proposal. So here in the example, I have kept my willingness to sell off my phone. That's the reason it is said I have given an proposal. I have given an offer to you to sell my phone. Second is section 2b, which is acceptance, that is promise. When the person to whom the proposal is made signify his assent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. So as I said, once the what is the formula for promise? Offer plus acceptance. So once the willingness has been kept in front of other person and the other person accept that willingness, that acceptance immediately turn that offer into a promise. Section 2c talks about promiser and promisee definition. So the person making the proposal is called as promiser and the person accepting the proposal is called as promisee. So in this situation, I was the promiser and you were the promisee. Next is section 2d, consideration. When at the desire of the promiser, the promisee or any other person has done or abstain from doing or does or abstain from doing or promises to do or abstain from doing something, such act or absentee or promise is called as consideration for the promise. So here in this situation, as I said, I have considered the money and you have considered the mobile phone. Next definition is section 2e, agreement. Every promise and every set of promise forming the consideration for each other is called as agreement. Next is section 2f, which is called reciprocal promise. Promises which form the consideration or part of consideration from each other are called as reciprocal promise. In simple language, we can say that promise ke badle promise. Next is section 2d, void. An agreement not enforceable by law is said to be void. Next is section 2h, contract. An agreement enforced by the law is said to be a contract. Next is section 2f, voidable contract. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of other or the other, is a voidable contract. So as I said, one party is agreed and the other party is disagreed. Last is section 2j, void contract. A contract which enforceable by law becomes void when it ceases to be enforceable. So such kind of contract is said to be void contract. That's it for today's lecture. End of today's lecture. Thank you.